Hello, my name is Joshua Gilliland, and I am the attorney blogger for Bowtie Law. Together with Jessica Meterson, we are the Legal Geeks, and thank you for joining us today for another episode of the Legal Geeks educational series. Today, we are focusing on reviewing electronic discovery. This is a huge issue for many attorneys because for some, it is a fantastic opportunity to learn a new skill set and to become of great value to their firm. For others, they are terrified of it. First off, what are we dealing with here? Are we dealing with networks of information, electronically stored information as one would imagine it inside a computer? Well, the answer is not that. It's a little more fundamental. Reviewing electronic discovery is just the same as reviewing discovery, except we have moved way beyond boxes of paper, and we are required to use a review platform to sort and to review the information and to maximize different search technology out there to find what is relevant to a case. Tom Moway, professor at the University of Arizona, wrote in one of his trial books that in a complex case, you're probably going to have 20 trial exhibits. In a normal, simple case, that's probably more like 10. When you're dealing with gigabytes to terabytes worth of information, that's still a lot of email and Word and Excel files to sort through to find those smoking gun documents. Well, that is electronic discovery. It's finding out what are the 10 exhibits that we are going to need to prove to a jury our client's position. So let's review. First, metadata. That is data about data, and it is absolutely imperative to have different kinds of metadata in our review platforms. The reason for it is simple. It is free objective coding. Objective coding in a review database can be made up of extracted text or perhaps embedded or substantive metadata that shows the who, the what, and the when a document was created, who edited the document, who printed the document, what time an email message was sent, what time a text message was received. All of that makes up a lawsuit. All of that information tells the story, creating a chronology of events, and tells us who the players were in taking a part in this dispute. It is absolutely imperative to have this information to maximize the search capabilities of the review products commercially available, and it also enables us to have a database that's populated full of information that's objective. Subjective coding is what takes an attorney looking at something and going, you know what? A particular privilege applies to this. This is subject to the clergy privilege, or whatever could be relevant, to that case. Or it shows this applies to a particular cause of action. Moving on, how do we review this? Well, first, we need to have a strategy when we do document review. If we are the plaintiff, many like to review for causes of action. They take jury instructions and they put together issue tags based upon their jury instructions supporting the different causes of action. Conversely, defendants generally review for defenses, things that attack the different causes of action. And it's important to know both and to know what you're looking for so you're not simply wading through other people's email messages, getting caught up in the soap opera of their lives. So to build these issue tags, conduct client interviews. Look at the allegations of the complaint if you're the defendant, and take that information and build it in as issue tags for what you need to look for. Think of your defenses and come up with your defense list and have those as issues that you're going to look for. Additionally, the strategy helps for initial disclosures and being able to identify what supports those claims or defenses that you need to disclose to the other party at the time of the meet and confer and before the Rule 16b conference. And another source of terms that could be issues are the definitions from the different discovery requests. All are very handy in coming up with the issues that could be relevant to your lawsuit. Other things to consider is who are the key players? What are the date ranges? What are the files that we are looking for in this lawsuit? One of the biggest and most expensive mistakes attorneys can make in electronic discovery is treating ESI like it's just a box of paper to start wading through. Bad idea to do that. Leverage the technology to narrow down to particular individuals, filter down by date ranges, and if you can go, you know what, we're going to have to deal with a lot of CAD files in this litigation, zero in on those. If this is a case that's going to deal extensively with email, look at the email messages. If we're going to be looking at different types of Excel files, now again, think about those things that will enable you to be successful in document review. So again, you just don't want to get caught up in the soap opera of other people's email and trying to piece together your case. Privilege review is simply more than tagging an email message or a Word document confidential. You have to consider the privileges that are going to be at stake in the case. For example, perhaps you're going to be dealing with a lot of trade secrets. Perhaps there are other business type privileges that attach. Perhaps there are going to be spousal privileges that you need to consider as well. And you take all that information and you create your issue tags to be able to tag information accordingly. Now, it's more than just simply tagging it privileged. Think about Rule 26 and what is required for a privilege log. Define that information and either create sub-issues, so you can say it's a communication from attorney to client rendering legal advice, or if the reviewing attorney has to check a box that says spousal privilege, they then have to go in and edit how the spousal privilege applies. And with that, you can create the privilege log while you're doing document review, and when it's time for the production, you can produce an Excel spreadsheet right from your review platform. Virtually all of them have the ability to do that, and it saves hours of time in the monotony of building a privilege log because you're doing it as you conduct document review. Another piece of eDiscovery review that is imperative is effective project management. People have gotten into lots of trouble about this. First off, you want to be able to have open communications between the attorneys working on the case, and if you have eDiscovery professionals within the law firm or within your corporate client, make sure everyone's communicating. So that way if production gaps become apparent, people can respond. How can we all of a sudden have a month of zero email? Maybe 5 days of no email from someone meant that they were on vacation. Those are the types of things to discuss. Additionally, you want to document the entire decision-making process. Frequently, people just exchange emails back and forth, either with a service provider or with other people within the firm, and that information can be lost. Those decisions can be lost in somebody's inbox. If you have a case wiki or a project management tool of some kind, you can see what decisions were made and understand why something is the way it is. It's profoundly important to be able to answer those questions, because if 6, 12, or 18 months have passed and somebody's no longer with the firm or someone's no longer with the service provider, that could make explaining why a decision was done profoundly difficult. There's good old-fashioned quality assurance testing. That can be from load files, especially when you're doing a production to the opposing side. You also want to test internally. Are the search terms we're using making sense? Another thing to do is to define review protocols. How do we review electronic discovery in this law firm? What's our strategy? What do we look for? What terms do we use so they're consistent, so no one's making up things as they are reviewing things on an ad hoc basis, but there's basically a vocabulary that everyone has agreed upon. Another issue for people to consider is defining checklists. If you're about to do a discovery production, define who does what. follow a checklist so that way you know exactly everything's been done, a privilege log is included, the load files have been tested, the redactions are sound, there's no inadvertent production of metadata that needed to be not produced because ESI had to be converted to a static image and then redacted, and then OCR done on that redacted image, and you don't want to inadvertently produce the metadata that you would otherwise not. So again, all these things you need to consider. But at the end of the day, have a process that you document and follow it. This is just the tip of the iceberg when it comes to electronic discovery. We hope that you find it helpful when you start considering eDiscovery review, and we certainly appreciate your time. Tune in again on The Legal Geeks for more tips and explanations of electronic discovery and other legal issues, and for all things geeky. Thank you and have a wonderful day.